here for oral argument today. Parties have already been logged in by Madam Clerk. We've got Alaska Wildlife Alliance over on the right-hand side, on my right-hand side of the courtroom over at the plaintiff's table. And the defense side, representatives or attorneys for the state of Alaska. And who will be arguing today? Could counsel just stand and give an introduction to yourselves? Are you Mr. Booking or Mr. Bennett?
Sure, I'm Joe Geltock,
Oh, okay.
and I'm one of the counsels. Mr. Bennett and I have decided that we will allocate our time somewhat differently. We intend that he will do the rebuttal portion, and I will do the open portion.
No problem. All right. And on the other side?
Yeah, thank you, Your Honor. This is Cheryl Brooking for the state of Alaska. And with me, I have Natalie Weber from the Department of Fish and Game, and Kimberly Del Frade, who is Assistant Attorney General.
Okay, thank you. And will you be arguing alone for the state?
Yes, I will, Your Honor.
All right, thank you. All right, counsel? Scott Booking.
Judge, good afternoon. If it please the court, Mr. Bennett and I are here representing the Alaska Wildlife Alliance. And with us is Carol Danberg, who is the president of the Alaska Wildlife Alliance. The Wildlife Alliance, and I'll sometimes refer to it as the Alliance or AWA for indulgence, has been in Alaska active in expressing an interest and advocating for wildlife for over 4 decades. They are not just a bear-specific outfit. They are interested in bears, black bears, brown bears, polar bears. We're also interested in ulupin, one of the important feeder fish of belugas. They routinely appear before the Alaska Board of Game. I think last year they appeared and commented on 70-some proposals that were before the Alaska Board of Game. They have a long history of involvement representing Alaskans regarding public wildlife resources. Their interest is not always adversarial. They have a history of cooperating. Most recently, they cooperated with various trappers in Alaska to come up with a sensible proposal that protected dogs and other domestic wildlife, and also some wildlife, from trapping near heavily used trails. I think virtually everybody in here, the great majority of people who entered your courtroom today, have an opinion about wildlife. At the end of the day, really in about 2.5 hours, there's only one opinion that's going to matter, Your Honor, and that's yours on the case before you.
Usually it'll be in 2.5 hours. Might be a little longer than that.
That's, as you say that. The issues and basis for the court's opinion and decision really revolve around 3 issues, at least in the opinion of the Alaska Wildlife Alliance. They are standing, due process under Alaska's Constitution, and the application of Alaska's constitutional sustained yield mandate. Let me assure you, Judge, Alaska Wildlife Alliance is not seeking, in your opinion, a decision in this matter. A decision based on speculative law or unreally guided policy. What AWA requests, and what's warranted in your decision, is a decision based on the express language in the Alaska Constitution, the intent of our constitutional framers, and that's grounded in the obvious and long-standing pronouncements by the Alaska Supreme Court. Let me turn to the first issue, standing. The Alaska Wildlife Alliance has standing in this case. Their long-standing interest in maintaining, protecting, and using Alaska's public wildlife resources is obvious. The Alliance has appeared and testified before the Alaska Board of Game regarding not only this issue, but many other issues. Under either test that's been articulated, and that's been on the book, so to speak, for decades, the test for standing, whether it's interest, injury, or citizen taxpayer, the Alaska Wildlife Alliance meets test. I think the court is familiar with the various tests. Your Honor, you've been on the bench a long time. I don't need to recapitulate cases and drone on about that. extensively, other than to point out the obvious. The basic rule of standing is to ensure that there is adversity, so that there's a real case in controversy, there's no sham. That, of course, comes from one of the tests. But the foundation that's articulated by our court, starting with trustees most obviously, which is practically a horn book on standing, 40 years old now, is that the litigant have an interest in the case. 3 cases that have been presented to you underscore that. I mentioned trustee. It's the fundamental basic beginning for understanding standing. The second case I think that's worth looking at, which was cited by the state, is the Nice case. This is Nice versus various brands or badges of Lithia, Chrysler, Lithia, Hyundai, and everything else. The state proposes that, and it's really, at least in my reading of their briefing, the only case that talks about there has to be actual injury. It's an interesting case, easily distinguished, because, and I think these aren't my words, this is Justice Carpenetti writing for the unanimous court.
May I interrupt you just for a moment to something administrative, Madam Clerk? I'm finding these, perhaps you as well, the telephone line, people coming in and out, a distraction. Can I ask you to lock the line, please, so we won't have that anymore? I'm sorry if people are joining us late, they just won't be able to get in, but they had 15 minutes to show up. And I'd rather not have the beeps going on and off throughout the game.
If there's a end the ding dong, it's good by me.
All right, let's end that ding dong, thank you.
Yeah. Nice case, which I call Lithia because it just seems easier, is easily distinguishable. You had some revved up lawyers who thought they had a really good class action case, and they sued as many of the Lithia brands as they could get, and I'm sure they thought they were going to have a nice recovery under the unfair trade practices provisions of the statute. That is not what is going on in this case. I can see the appeal for the state of Alaska because Justice Carpenetti and the court talked about the injuries, and the plaintiffs had not pled injury with regard to 2 of the things. The basic thing was nobody bought a vehicle, used or otherwise, from a couple of the entities. I think that case is easily distinguishable from the case before you. And I won't belabor it, and I'll simply point out the third case that I think is noteworthy with regard to standing. That case was decided in February 14th of this year in the Michelle Stone Bittner case versus the state of Alaska. Our Supreme Court...
You are muted.
All right, thank you. The price of greater public participation. I apologize. Bittner case. Take it from there.
Bittner case. It's a recent case. The Alaska Wildlife Alliance, we have provided the supplemental briefing. It's a case that stands for the unanimous court found Michelle Stone Bittner in a case that was remarkably similar to the case that we're arguing about today, had standing. And it really in some ways recapitulates the old standing that's been on for 4 decades, starting with trustees and even cases before that like Moore, that if somebody has an interest, and if they have adversity, they get to argue on a matter of principle. It doesn't have to be an injury where somebody's sideswiped by an F-250. A small amount of interest counts to argue something as a matter of principle. And principle is what's involved here. The principle that is most affected here are 2 constitutional provisions. What could be more essential to our state and the rule of law than ensuring that the citizens are afforded due process under the law? There's a reason why due process is up in Article 1. There is a hierarchy, at least in my belief, on constitutional provisions. That doesn't mean Article 8 and some of the subsequent are of insignificance. But there's a hierarchy our framers established with regard to due process. It's right up there in an important aspect of our constitutional protection. The notice to the Alaska Wildlife Alliance and the public about this idea of removing bears on state land was deficient. No mention was made about removing bears. No mention was made in the notice, whether it was the generic notice that talked about there's going to be a meeting or the specific notice related to Proposal 21, which dealt with wolves being removed from federal land. No mention in the generic or specific notice on Proposal 21 about taking bears out from state land. The court and anyone with an interest in this issue can scroll through the record. You can look at it, and it's cited in the briefs. It's available as public documents. The generic notice and the specific notice. It's devoid of mention about bears and harvesting them on state land. The eventual proposal, the one that morphed from Proposal 21, after public testimony, after the ability to comment on it was closed, is radically different. This is not a mere amendment. You know, looking at the Alaska Administrative Procedures Act, 4462-200, which really just fleshes out due process requirements guaranteed in the Constitution. There is an ability to modify and make amendments, but they can't deviate and be so substantially different in form, in scope, and content that you get to do whatever you want as a bureaucrat or an agency. The radical departure here from the original call to remove wolves on federal land is not an amendment. It's a radically different proposal that required new notice and a new ability for the Alaska Wildlife Alliance, for any other member of the public, be they bear guides or anything, to have notice and comment on that before we lurched off into this new bear killing regime. I'll turn to sustainability. The state makes much about, and sometimes they even refer to maximum sustained yield. No such concept is sanctioned by the Alaska Constitution. We have maximum beneficial use in one provision. We have a requirement that replenishable resources be managed and maintained sustainably. But the state sometimes conflates the two, essentially, or at least unconsciously saying, well, we get to do the balancing. This court, you, Your Honor, get to do the evaluation. There's no balancing. In one sense, the hard look test articulated by our Supreme Court, the hard look test that the agencies must engage in is what you have to review. Sustainability, according to our Supreme Court, requires that important material relevant factors related to sustainability have to be considered. If they are, and there's at least an adequate job looking at that, having a basis for that, you can and would be justified in deferring to the agency's determination. You cannot in this case. I'll give you a couple reasons why I think the agency failed to do that. They were focused, they were mesmerized on caribou. If you look at the discussion, you look at the briefing, it's all about the Mulchatna caribou. Caribou, caribou, caribou. In that short period of time, when there was no notice, no opportunity to be heard, and a member of the Board of Game kind of pops up and says, just before lunch, what about bears? What about bears apparently resonating with people? But the context is about caribou. The context was saving caribou. What about bears should have been followed? Well, what about bears? What about bear population? What about bear sustainability? What about bear reproduction rights? If we're gonna take bears, should we have a quota, a cap? How long are we gonna do this? All of the questions, important material, relevant questions about bear sustainability were glossed over in the haste of the Board of Game to engage in a bear killing regime under the misguided thought that they were gonna improve caribou capping. I don't even need to go in, not extensively, Your Honor, into the state's attempts to engage in this post hoc rationalization, things that they did down the trail and to justify the act they took, which did not consider sustainability. Other than to note, this court narrowed the focus of the litigation properly at one point during this, and basically took all the post hoc rationalization off the table. At least that's how I view it. So let me conclude, Guy, with what may seem like an odd ask of you, and which might cause Ron West to blanch. Maybe some other people in this courtroom. Forget about the bears. This is a constitutional issue. Your duty, and I know you know your duty, forgive me if I seem like I'm being pedantic, rule on the Constitution. This court has a demonstrated history, a recent history, in taking on tough issues and ruling on constitutional issues. The takings issue in the ConocoPhillips case. You didn't back down from addressing a tough issue, one that the state has already appealed. Please don't do it in this case. The citizens of this state, the Alaska Wildlife Alliance, and frankly, the state of Alaska need clear directions from the judiciary that Article 1, Section 7, our due process, means what it says. Article 8, Section 4, the requirement that you engage in reasoned analysis about sustainability of a protected resource, a constitutionally protected resource like bears, means what it says. The ask of the state of Alaska really comes down to a request from the judiciary to sort of rationalize or slide over bureaucratic sloth. Don't do it. The Constitution, as written, as it was intended by our planners, and as it's been interpreted by the Alaska Supreme Court, requires no less. Thank you. And the balance of our time reserved will be for Mr. Bennett. Thank you. Thank you, Counsel. You have the floor.
May it please the court, I'm Cheryl Wells-Brooking for the state of Alaska. Online we have Mr. Ryan Scott, who's the director of the Division of Wildlife Conservation, and Mark Birch, who's the assistant director. With me in court today we have Regional Supervisor Tim Peltier, Acting Intensive Management Coordinator Chris Brockman, Assistant Management Coordinator Manny Eichholz, Regulations Coordinator Natalie Weber, and Assistant Attorney General Kimberly Belfrade. The Board of Game adopted amendments to an intensive management program designed to assist in the recovery of the Mulchatna caribou herd. We start with the allegations made in AWA's complaint. Paragraph 11 stated that the substance of its complaint is confined, and that's their word, confined, to whether Proposal 21 was improperly amended by the board to include predator-controlled bears in February 2022. Commissioner Vincent Lang was named as a defendant, but there are no allegations made by AWA in the complaint against the commissioner, only against the Board of Game. So for that reason, the state asks that he should not be a party to this case. He should be dismissed and considered a prevailing party. The legal and factual framework is important to understand what happened and why. The legislature directed the board to adopt intensive management regulations. When it passed the IM statute in 1994, the legislature included a statement of its intent, finding that providing for high levels of harvest for human consumptive use in accordance with the sustained yield principle is the highest and best use of identified big game prey populations in most areas, and that the big game prey populations in these areas should be managed accordingly. The IM statute found in AS 1605-255 is not mentioned in the complaint, but that statute is what's really underlying what the Board of Game did. The board is directed, the board shall adopt regulations to provide for intensive management to restore the abundance or productivity of identified big game prey populations as necessary to achieve human consumptive use goals of the board in an area where the board has determined that three things. One, consumptive use of the big game prey population is a preferred use. Two, depletion of the big game prey population or reduction of the productivity of the big game prey population has occurred and may result in a significant reduction in the allowable human harvest of the population. And three, enhancement of abundance or productivity of the big game prey population is feasibly achievable utilizing recognized and prudent active management techniques. These are decisions that the legislature has made. The Constitution gives the authority over resources to the legislature. The legislature has in turn delegated authority to the Board of Game and the Department of Fish and Game. The board has made each of those three determinations that are outlined in the statute that I just read to you. The board identified Mulchatna caribou as important for human consumption. They did so by regulation. An intensive management plan was first adopted by the board in 2011, authorizing the take of wolves in a defined area. In 2022, this is what this case is really about, the board expanded the area where predator control could occur and authorized the take of black and brown bears as well as wolves. In the western calving area, bears were identified as having a significant impact on the survival of caribou calves within their first 2 weeks of life. Other factors were also identified as possible factors in the decline of the population, but this is something that the state could do something about. An operational plan was developed by the department and presented to the board and to the public prior to predator control activities in 2023. This plan provides detailed information about the Mulchatna caribou herd as well as intensive management over time since the board first adopted the first IM regulation in 2011. The plan also provides information on research efforts conducted by the department. Information provided to the board in January 2022 about the brown bear population showed that there are a lot of brown bears in Unit 17. Brown bears are widely distributed in Unit 17 in abundance. The average harvest since 2000 has been 116 per year. Commercial guiding is an important factor for brown bear harvest, and the bag limit is 2 bears per year. The local Nushagak AC Advisory Committee reported that the bear population is increasing. The Naknak-Kwichak AC also reported a large number of bears and was in favor of reducing the bear population. So with that background, I want to provide just a reminder of some of the standards that this court is directed to use in reviewing this case, consistent with guidance provided by the Alaska Supreme Court. The court is to defer to the agency's interpretation if it has a reasonable basis in the law. If a case may be fairly decided on statutory grounds or on an alternative basis, then the court will not address constitutional issues. Article 8 effectively limits the judiciary's role in implementing Alaska's natural resource policies. The court does not provide instructions on how the state should determine what action would be for the maximum benefit of the Alaskan people. The sustained yield principle is one of general management and does not provide any specific directives. And this court will not overturn an agency decision simply because a group of users disagrees. Review of a regulation adopted under the APA, where the legislature gave the agency discretion, is limited to determining whether the regulation is consistent with its authorizing statutory provisions and whether it is reasonable and not arbitrary. So with that Supreme Court guidance in mind, let's first address whether AWA has standing. No injury was alleged by AWA. So the Neese and Keller decisions require dismissal for lack of standing right out of the gate. We just heard about the recent Bittner decision. That reinforced that Alaska has a liberal stance on standing, but confirmed that there must be some harm. AWA asserts that it brought this case in the public interest. The fact that local fish and game advisory councils, the Alaska Federation of Natives, the Tanana Chiefs Council, and many other individuals support the predator control activities to help the caribou herd population recover completely negates the assertion that AWA represents the public interest. This is the first opportunity the state has had to address arguments made in AWA's reply brief. In its reply, AWA cited to Friends of Willow Lake and said that AWA has standing for the same reason that the nonprofit plaintiff had standing in Willow Lake. But that's not so. In that case, the purpose of Friends of Willow Lake, or FOWL as they were called, was to protect the interests of the users of Willow Lake. The members were all Willow Lake users, and some members owned property on the lake. Here, there's no evidence that any AWA members have a connection to the caribou or the bears or the area involved in Unit 17. To quote from Willow Lake, and in turn citing to Alaskans for a Common Language versus Crits, the court said, "We recognized and specified criteria for associational standing, allowing a group to represent its members' interests. We stated that," and I quote, "an association has standing to bring suit on behalf of its members when, 1, its members would otherwise have standing to sue in their own right, 2, the interests it seeks to protect are germane to the organization's purpose, and 3, neither the claim asserted nor the relief requested requires the participation of individual members in the lawsuit."
You know, in the Bittner case, it was argued by the state, and I don't recall that it was really disputed that Michelle Bittner had never even been to the area that was the subject of regulation in that state. She was a very amorphous interest that she had in the well-being of bears, and I rely on memory, but it seems that that's an argument that has been tried and failed, at least in the Bittner case.
I would disagree with that. In the Bittner case, what the court said is that she had claimed that she had been to Katmai National Park over 100 miles away, and that after the implementation of predator control, she went back to Katmai and believed that there were less bears there. So on remand, she will then need to, of course, prove those allegations. But accepting all of her allegations as true and factual for purposes of a motion to dismiss, the court found that that was sufficient to establish standing. She had alleged some actual harm in her ability to view bears at Katmai. And in this case, we don't even have that. We have nothing, no harm. So AWA has not shown a, quote, sufficient personal stake in the outcome that's required to challenge a regulation. They merely disagree with the board's regulation, and disagreement does not confer standing. In the Louth case, the court held that disagreement does not equate to a direct and personal injury. And the court repeated that in the Koyukuk case, that mere disagreement does not provide a cause of action. Also in its reply, AWA cited to paragraphs 1 through 3 of its complaint in support of standing. So let's take a look at those. Paragraphs 1 and 2 essentially say that AWA brought this lawsuit to challenge the adoption and implementation of the Mulchatna Caribou IM regulation. There's nothing there to support any harm or to support standing. Paragraph 3 asserts that AWA members use and enjoy wildlife in Alaska. Again, there's no evidence of any connection or any evidence of any harm to any of the members as a result of this regulation. There's no injury to be redressed by the court. In the reply, AWA mischaracterized both the Canick and the Bennett cases. In the Bennett case, the state actually did raise a question of standing several times, but AWA is correct that the state did not move to dismiss for lack of standing, and probably should have. Regardless, the state prevailed on all claims that were brought against it by AWA. There was no unsustainable wolf harvest in that case, and there was no violation of sustained yield. In Canick, the plaintiffs alleged personal specific facts to support standing. A general interest in Alaska wildlife does not demonstrate any connection or harm caused by statutorily required management regulations. AWA asserts that it has a sufficient stake in the outcome, but there's no explanation of how its members were harmed, either through predator harvest or increased survival of caribou calves that resulted from the implementation of the regulation. And I do want to mention that throughout AWA's briefing, there's a lack of citations to law and to the administrative record that makes it somewhat difficult for the state to respond to some of the statements that were made. We, in some cases, really don't have any idea what they're relying on, or whether there is anything for AWA to rely on for some of the statements that were made. An example of an argument that was not supported by the record is the assertion that Proposal 21 would limit predator control to federal lands and Unit 18 only, when AWA clearly knew the predator control area was proposed to be expanded to include both state as well as federal lands. There was never a change or even a proposed change from federal stand to state land alone, as they've asserted in their briefing. And again, like many other places in the opening and reply briefs, there's a multitude of statements without any citations to law or facts. Next, the board's amendment of Proposal 21 in 2022 was sufficient under the APA. There's no need to address constitutional claims when this can be resolved on statutory grounds. And that's from the Alaska Fish and Wildlife Conservation Fund versus state. In that case, the court also upheld the amendment of a regulatory proposal holding that it was within the scope of the subject matter in the notice of the proposed regulation changes. And I notice this case has not been mentioned or addressed by AWA in any of its briefing. This is essentially not a constitutional case. This appeal can be resolved without addressing any constitutional provisions. Due process is really a statutory claim under the APA, specifically AS 4462-200B, regarding whether the amendment to Proposal 21 was within the subject matter of the board's notice and whether AWA was able to participate in the rulemaking process. Board regulations are adopted under the APA requirements. The board solicits proposals for regulation changes. Anyone can submit a proposal. The board publishes these proposals and a meeting notice soliciting public comments on these proposed regulation changes. The notice must include, under the APA, an informative summary of the proposed subject of agency action. And the board is expressly authorized by the APA to amend regulatory proposals that come before it. Proposal 21 was amended within the subject matter of the public notice as allowed by the APA. This statutory provision was previously cited by the Alaska Supreme Court in the Alaska Fish and Wildlife Conservation Fund case. And again, the court in that case found that the amendment was within the scope of the meeting notice. In this case, the APA notice advised the public that the board may reauthorize existing intensive management programs as well as establish new programs, including predator control implementation plans. The notice named several caribou herds, including the Mulchatna caribou herd. There was no radical change to Proposal 21 that was outside the scope of the meeting notice. The notice broadly addressed predators without limiting the board to any specific predators. The notice also included language for proposals to be addressed at the board's March meeting as well as the January meeting. And on page 2 of that notice addressing the March meeting, there was listed control of predation by wolves. That limited the subject matter to wolves at the March meeting. That limitation was not in place for the January meeting. It was any predator. There was no intent to limit the board's authority. And the plain language of the notice supports this. The board's notice also advised the public that proposals could be amended. And the statutory ability to amend a proposal has been acknowledged by APA in their briefing. The notice stated in bold, all caps type, quote, "The board is not limited by the specific language or confines of the actual proposals that have been submitted," end quote. So to prevail, AWA needs to prove its claims and must overcome the statutory presumption that the board's regulation is valid. That statutory presumption is found in 4462-100. There's no due process or APA violation. AWA had notice of the meeting, was present, and provided written and oral comments on a variety of proposals. AWA knew that the board would consider Mulchatna caribou predator control. And again, the notice did not specify what type of predators would be controlled. The board's amendment was within the subject matter of the meeting notice. AWA had noticed that the board might reauthorize or establish new predator control regulations to benefit the Mulchatna caribou herd and might amend proposals that came before the board. They had adequate notice and a fair opportunity to be heard. AWA argues that they had no opportunity to be heard on RC 47, and that contained the proposed amended language for Proposal 21 to include bears in the predator control regulation. But the meeting continued for 2 more days, and AWA did nothing. No RC comments were filed. No request for reconsideration was made. AWA states that nothing in the department comments on Proposal 21 addressed bears, but that's really kind of irrelevant. That is correct. When the department presents comments on a proposal, it's not required to anticipate any possible amendments that could happen at the board meeting. Board members go into meetings open-minded and ready to consider written public comments, oral testimony, and information presented at the meeting, and that's exactly what the board did. The board considered information about the impact of bears on calves within their first 2 weeks of life. The board considered testimony about the high and growing population of bears in the area. There were several days of public testimony. There were hours of department presentations from biologists on research and hunt management and intensive management before the board ever got to deliberating on Proposal 21. All of that information was available to the board members and was properly considered by them. So to suggest that all of this happened in just a couple of minutes is disingenuous. Later in 2023, before implementing the IM program, the department prepared an operations plan. This plan was made available to the public on the department's website, was known to AWA, and is referenced in the complaint. AWA was at that 2023 board meeting where the Mulchatna caribou herd and intensive management was discussed and did nothing. The board goes above and beyond APA procedural requirements by allowing days of oral testimony as well as additional written comments to be submitted throughout these multi-day meetings. More process was provided than was due. To summarize, Proposal 21 was adopted as amended in January 2022. AWA provided written comments on proposals, was at the meeting, gave public testimony, was present when others testified about the increasing bear population, and was present when the impact on caribou calves from bear predation was discussed. There were days of public testimony, hours of presentations, as I've said. The predator control activities were not carried out until May and June 2023, more than 16 months later. During those 16 months, there was no communications from AWA to the board or the department. Next, AWA is wrong in alleging that there's a constitutional requirement in the sustained yield clause mandating what information must be presented to the board. In the Sitka Tribe 2023 case, the Alaska Supreme Court declined, quote, to create a constitutional requirement that is not in the plain language of Article 8, Section 4 of the Alaska Constitution, and that would infringe on an area constitutionally committed to the legislature, which the legislature has delegated to the department and the board. The court held that deciding what information is relevant and how it is shared is within the department's discretion under AS 16.05.050. And we've just heard Mr. Geldof say that AWA is asking this court to look at the express plain language in the Constitution. There is simply no constitutional sustained yield claim here. It's really, again, a statutory claim, if anything, under either the APA or the Intensive Management Act. But those provisions have not been met. AWA has to overcome the presumption of the validity of a regulation, and there's no mention at all of any action taken in violation of the Intensive Management Act. The board, by law, was directed by the legislature to manage with preference for caribou. The board considered the bear population, but the focus, as required by law, was to aid in recovery of the caribou. So now let's take a look at the actual allegations made in the complaints. And this starts on page 17, paragraph 776, alleges the board improperly amended Proposal 21 when adopting that proposal in January 2022. And I've already explained that AWA has not proved that allegation. The board acted within its statutory authority. Paragraph 77 alleges the board failed to manage the bear population in the area inhabited by the Mulchatna caribou. Did AWA prove this? No. The Alaska Supreme Court held long ago that the intensive management statute and predator control is consistent with sustained yield, and that the state can appropriately favor one species over another. And both the legislature and the board have done so. No claim is made that the IM management program regulation is inconsistent with the IM statute. And the legislature's intent in 1994 was to manage for sustained yield, recognizing big game prey populations such as caribou as the highest and best use of game for human consumption. The state's brief refers to evidence in the record that the board considered. There was a high and growing bear population. Bear predation is a significant factor in caribou calf survival during the first 2 weeks of life, specifically on the western calving area. Wolves were more prevalent as a problem in the eastern calving area. More details are in the state's brief with references to the administrative record, and I refer you to pages 4 through 8 of the state's brief. Going back to the complaint, paragraph 78 alleges the board failed to, quote, failed to observe and follow the mandatory protocols applicable to replenishable resources for the bear population in the area, close quote. The state is not really sure what mandatory protocols are referred to here. It seems that all parties agree that the APA provides mandatory statutory procedures for adopting regulations, and AWA did not prove that the board did not comply with those procedures. There are no constitutional mandatory protocols in the sustained yield clause. Paragraph 79 alleges the board adopted Proposal 21 without taking a hard look at the factors impacting the bear population. The board's decision, again, was for the purpose of aiding in recovery of the caribou population, and it appropriately recognized a preference for caribou over bears in that area, while also considering information about the high and growing bear population. When the Caribou IM program was first adopted in 2011, bears were excluded from predator control because there were too many bears in the area. The board did take a hard look at a wide variety of factors impacting the Mulchatna caribou and made decisions about how to address those issues in a reasoned manner. The state pointed out relevant information included in the administrative record that the board considered. Several potential factors were identified as causing a decline in the Mulchatna herd including bear predation on young calves. The Alaska Supreme Court held that the role of the court in reviewing is limited to determining whether the agency took a hard look at material and relevant information, and that's from the Savuna case. Paragraph 80 alleges the adoption of Proposal 21 violates sustained yield, but AWA has not shown that to be the case at all. The record shows that there are a lot of bears, and the information presented to the board in 2024 shows there were more bears than expected, and the reduction of bears in 2023, quote, was consistent with an improved summer survival of western Mulchatna caribou calves, higher fall 2023 calf-cow ratio. Paragraph 81 alleges there is no, quote, credible scientific basis, close quote, to support the board's decision to allow the take of bears. Again, the state's brief cites to specific evidence in the record showing that the professional biologist presented information to the board about the decline of the caribou population, along with the impact of bears during the calving season. The board also considered input from people who reside in the area and depend on the caribou. AWA offers no proof that there was no credible scientific evidence supporting the board's decision and has not proved its allegation in paragraph 81. So those are the allegations made in the complaint. There's one more. Paragraph 82 alleges there was no scientific information considered by the board about the bear population, but the administrative record shows that the board did hear from the department. It did not have a recent brown bear population estimate, but the board also heard of the growing bear population and a desire to reduce that bear population. It was not necessary to know the actual number of bears in the predator control area in order to take action to aid in the recovery of the caribou population. The board did not need more detailed information on the bear population, and the information presented by the department in 2022 was statutorily up to the commissioner's discretion. The operations plan presented in 2023 included more information on the bear population, the history of intensive management in the area, as well as the caribou population. There was much more detail in that before any implementation of the regulation was begun. Paragraph 83 alleges sustained yield has primacy over any preference among beneficial uses, but that statement is flat out wrong as a matter of law. The sustained yield clause, the language in the actual Constitution, includes the language subject to preferences among beneficial uses. When the IM statute was passed, as I said earlier, the legislature made the decision to recognize big game prey species as the highest and best use of game and important for human consumption, consistent with sustained yield principles. The legislature used the constitutional language subject to preferences among beneficial uses in adopting the statutory definition of sustained yield for IM. And the Alaska Supreme Court recently held that the legislature had the authority to define sustained yield, and the statutory definition is valid and consistent with the constitutional clause. In its briefing, AWA raises some issues that were not raised in the complaint, so the state would ask the court to just disregard them. For example, the Supreme Court recently decided the Bennett case, another case brought by AWA. It's proper to limit the scope of the court's decision to the claims actually made in the complaint. The state addressed some of these allegations in its brief, including whether the board considered fiscal information and whether a legislative appropriation was needed. These allegations are not properly before the court, and besides, the board actually did discuss these matters in a public meeting in January 2022, while acknowledging that the board lacks administrative, budgeting, and fiscal power. Those are powers of the commissioner. And again, there are no claims made against the commissioner. So in conclusion, going back to AWA's assertion that this lawsuit is confined to whether the board improperly amended Proposal 21, AWA has not met its burden to overcome a valid regulation.
Thank you, Kelsey. I think you have 10-15 minutes. Is that sufficient?
Yes, Your Honor. Thank you, Your Honor. My head's kind of spinning. That is a recitation, I think, of the almost the entire state's brief. I don't intend to comment on all of it, of course, in that short period of time, nor would I want to if I had longer time. I really want to just highlight some things that I believe are critical to AWA's, to Alaska Wildlife Alliance's claim and dispute in this case. Starting with standing, I hope that this issue has been laid to rest. Alaska Wildlife Alliance, if any organization in this, member organization in this state has an adverse interest, it's this group. In terms of its longevity, in terms of its appearances before the Board of Game, to object and comment on proposals, and in its very nature, it embodies the goal of protecting and conserving wildlife. And when those interests are threatened or damaged by what the Alaska Wildlife Alliance sees as improper acts and actions by the state of Alaska through the Board of Game, they come quickly to assert a claim. And I think that...
Can I ask you on that, Counsel, your take on the Bennett case? Do you agree with Ms. Brooking that I mean, it's possible to read the Bennett case in, I guess, a couple different ways. One way is that the court really just wants to make sure there's adversarial relationship, and the limited, I think that's a generous characterization of Michelle Bennett's interest in that particular action or impact on game was just kind of a fig leaf to give the court the basis for, you know, allowing the case to go forward. There was a fig leaf, and what could be clear, of an economic interest, of a harm. That, okay, I once saw them, and there were a lot of bears out there, and if I go back after the regulation, I see fewer bears, there's an injury. I don't know how you're ever going to prove, you know, maybe though something very creative, that the difference in the amount of bears you see is related to the regulation, or just it was a bad day for bears. I don't know, but that's one of the reasons that you sort of, it seems like the court is reluctant to let go of that, I'll call it fig leaf, that may be not the best term, but it's the only one that comes to mind, that there has to be some kind of harm as opposed to just sort of a generic interest in bears and emotional harm from the knowledge that the bear population has been diminished. How do you, anyway, what is your take on the Bennett case in relation to this case?
Well, that case, no, the state did not move to dismiss for lack of standing. And in several other cases that the Alaska Wildlife Alliance has brought against the state through the years, it has not been challenged and found to lack standing. I agree that, you know, the interest injury test is difficult and does have characteristics of what is the direct or more direct injury, or is that really necessary? I think, you know, several cases have squarely held that an interest can be intangible, an interest can be aesthetic, an interest can be environmental. Surely the members of the Alaska Wildlife Alliance travel all around the state to enjoy wildlife in a non-consumptive way and sometimes in a consumptive way. And I think you can argue both ways, that they have an interest that's central to their purpose, that's not direct and not actual, but then they also have, you know, a more direct relationship in their membership and what their members do. But I think if adversity is the cornerstone of standing, let me come back to that, because I can't see how anyone could view the Alaska Wildlife Alliance as not adverse in their business to the state of Alaska and the Board of Game, and when it sees management becoming a question that might threaten wildlife.
There might be a stipulation to that, I'm not sure.
You know, the word trifle appears in the cases too, and kind of a word that almost everyone who looks at standing picks up. And, you know, it's not a terribly significant amount of injury needs to happen. It's a trifle of injury. And I guess it's up to you to decide, you know, how you want to view trifle of injury. But in any case, I think we're in full disagreement with the state on standing, and probably always will be. I only have some time left. I want to briefly mention, you know, how the state opened, which was with intensive management. Intensive management is a program that's been in effect for many, many years. The Alaska Wildlife Alliance works with that program, understands that program, is not taking issue with that program. That program is designed to make an evaluation of predator and prey and deliberate and to adopt regulations accordingly. But what we're arguing on behalf of Alaska Wildlife Alliance is that when they do that, they really have to look, the board has to look carefully at not just caribou or moose, but also at the predators, be they wolves or bears. They can't just make a decision that there might be a lot of bears there. Or that there are a lot of bears there because the harvest is 60 bears, 70 bears, 80 bears. It's in the Alaska Wildlife Alliance's view, and they believe that, having watched the Board of Game and participated for so many years, that the board has to take a hard look, reasoned examination, careful examination of all the important factors that have to do with not just caribou, but the sustainability of the predators. The predators cannot be knocked down to a handful for the sake of caribou, because they are big game animals. They are valuable to many citizens of Alaska. There has to be a sustainability involved, a sustained number of bears. What is that sustained number? That's what the board is charged with evaluating. Did the board do that? No. Why? Because there were no current studies about bear population or distribution. The only studies were from another area over 10 years earlier. So, did the board discuss, did the board take a hard look about how many bears there might be out there? Or what the population really is? No, they didn't. Did the board discuss whether there should be a limit to the number of bears taken? Or was this to be an open-ended reduction program? They did not discuss a limit. These are the things that pertain to sustainability. I think the record reflects that in the time the board took to adopt that amendment that included bears, so little discussion was made about anything to do with the bears' well-being or health. It was all about the caribou calves. And the Wildlife Alliance does not disagree that bears take caribou calves in the first 2 weeks. That's what was testified about. But the other part, the sustainability part that applies to the bears, is the key issue for the Wildlife Alliance. And we believe it's squarely within the Constitution, under Article 8, Section 4, to point to that. It's the same deal. Finally, and I think, you know, the linchpin of this case really is about due process. This is really the main core issue in this case, and that's not to diminish what I just said about sustainability. But I think a fair and just treatment of a citizen in the course of executive proceedings is what due process, and the constitutional provision about due process says. Fair and just treatment. Well, was the notice really fair? Was the notice really fair? We say, on behalf of the Wildlife Alliance, it was not. Why was it not fair? Because the notice only mentioned wolves. The notice only mentioned wolves. And the public had testified through written comments and through its oral testimony in the public comment period only about wolves. The state says that it wasn't just about wolves, it was about predators. But the explanation under Proposal 21 is exhaustive. It's almost a full page long. And all it talks about is wolves on federal land, not bears on state land. That, in our view, Your Honor, is the notice, the full extent of the notice. And the reason it's insufficient is because when the board acted quickly, we believe, to adopt the amendment, to switch, to not switch, but add bears, state land, the public and Alaska Wildlife Alliance was left in the lurch because they had already testified on something else. Why? I think it's important to note that the program that had been in existence, the predator control program that had been in existence in Mulchatna for 10 years had only applied to wolves. So why would the public think that all of a sudden there would be a bear control program? Nevertheless, I think the state could have, the Board of Game could have cured this by holding another, opening the process back up, noticing properly, another meeting. Could have been 2 weeks later, it could have been a week later, it could have been a month later. And allowing people to testify on the full extent of what that regulation became. That did not happen. The state is trying to argue that subsequent activities a year later in various plans were enough to satisfy, to justify what happened. But really, we submit that what's most important is what happened before that vote. What was before they adopted the full regulation. After that, there was no more opportunity, meaningful opportunity to be heard. And that's what the case is focused on, a meaningful opportunity to be heard. Not, the state mentioned that somebody could, because there were 2 more days left in the meeting, somebody could have written, the representative from the Alaska Wildlife Alliance could have submitted a written comment and put it under the door of the chairman or something, but there was no real meaningful opportunity after that vote for them to be heard. And that, Your Honor, I think is the key failing in this case. The key matter that catapults it into a violation of due process, whether you judge that under the Alaska constitutional provision or whether you look at AS 4462-200, which amplifies the Alaska Article 1, Section 7, you come to the same conclusion. The due process was.
And if the court were to agree with you, counsel, what relief would you request?
I think the request would be to revisit the process, do it right, allow every interested party to come before the board and comment, and bring forth the information that I suggested the board should consider, and then adopt it. And I think if all of that had happened, we wouldn't be here today. I think it's just appealing to you, Your Honor, in the sense of what is fair and just in this issue, in this case. I'd like to think we're all working for the same end, the state and the Alaska Wildlife Alliance and others, which is to ensure, the viability and sustainability of all of our wildlife in this state. But we do have these disputes that I think are legitimate, and I wasn't going to say this because it's not really relevant, but I know something about the Board of Game, having served on it for almost 14 years. I know something about the process and what happened and what happens and what's common and what isn't. And if I thought this was a fair and just situation revolving around due process and the notice and the opportunity to be heard, I wouldn't be here today. With that, thank you.
Thank you, counsel, for being so you've done it. I appreciate the quality of the argument and the briefing. You both submitted proposed orders to the court that are trying to review. They just arrived to me. These were just brought to my attention, which I'm sure will be very familiar, having just heard your arguments. We'll probably track your arguments. Preliminarily, I'm not, you all heard the expression, what is it, once bitten, twice shy, is that what it is? And since you know who the author of the Bennett decision original was that was reversed, I'm not very strong on I guess I'm trying to say I'm not enthusiastic about granting dismissal based on lack of standing after reading that decision. It just seems to me to be, and I think the circumstances of this case outlined by counsel, I think it's pretty good job explaining why there's publicity. So I just don't think that standing is a strong issue. Certainly, after that decision, I don't think it's really I want to focus heavily on the arguments related to due process and, the actions of the court. And I think it's going to take more than 2.5, how much, you said 2.5 hours at the end before the judge makes a decision. It's more than 2.5 days, but I hope to get a ruling out within the next week. Certainly, as you probably know, I think I've told you in a previous status conference, my duration on the court terminates after March 17th, and I'm not leaving this unresolved for the next judge. I will make a decision prior to that, so that you have some certainty and you know where you sit. So we'll leave it there. Thank you all. I appreciate your interest. I'm sorry, someone raising their hand for a question? Anyone familiar with the Kathy B? I'm sorry? Kathy. I'm just a member of the public. Any third parties today, the representative parties are here, but some parties not there today? I don't think so. So, I'm not looking for any questions. Counsel?
I just had one question. I wanted to confirm that we just exchanged draft decisions today. You had earlier ordered that we have until this Friday to comment on
The other side.
the other side. That's
Well, thank you for reminding me of that. Thank